straight talk and what attorneys have to say later years in life. And so one of the first questions I think I will ask, just so we set precedents up front, you talked about you're doing estates and wills and estate planning. Do you still do real estate?
Yes.
Maybe expand on that.
Yes. Oh, yeah. So our firm still handles real estate transactions. So when people are looking to downsize or right size, move from the home they've been in for a while to something that's a little more manageable. Or when families call us, and that happens on a regular basis, where somebody is the family is in town for the funeral and they want to meet with somebody because they need to get the house cleaned out, and so we also assist with that. We partner with realtors who know exactly what they're doing in order to effectively market and get that house sold.
So let's go into the first question. Let's talk about documents that everyone should know and have ready. And as we all like stories of situations that may or may not go well, if you can also add something about that with the documents not being done, where just a simple meeting with you could have taken care of that.
We're gonna do this a little differently. Normally I have a very sort of formulaic presentation. So I thought today it'd be nice to just kind of chat with you guys for a while, and a lot of you are already my clients, so hopefully any stories I tell aren't your stories. But every person should have 3 basic documents, 3 building blocks of estate planning. Okay, the first one is a will or a trust, some sort of testamentary instrument that nominates somebody to be the person who wraps up your affairs and directs where you want your assets to go. And it could be as simple as to my kids equally, and one of the kids or 3 of the kids is in charge of everything. It could be as complex as an ongoing trust for grandchildren in the future and all that. The second document is a durable financial power of attorney. And that is a document where you, while you are alive and competent, designate somebody to handle your financial affairs in the event that you can't. And it can become effective right away when you sign it, or it can become effective in the future upon the proving of incapacity. And the last document is a healthcare directive. A healthcare power of attorney and a living will. And we're going to talk about that first, because we're going reverse order. So we're going to hit the healthcare proxy of it. So this is just a document where you indicate who you want to be your medical decision. And very often it is, people think about it as an end of life, designation. Who is going to be the person who decides whether to use life-sustaining measures or withdraw? But it's a lot more than that. And we've been running into this lately with clients who need assistance and perhaps are resistant to it.
So I'll just take it back a little further. When you do an intake with me, you would call our office, and once I get a little bit of information about what you need, then we'll set you up. And this isn't just in regards to estate planning, but we'll provide you with a series of worksheets that will help you before your appointment kind of get an idea of who you want to designate. And sort of take through that thought process about who's designated as an executor or an agent for your powers of attorney. They could be, multiple people, or one person, or even a family friend. So when you come in, you'll bring those worksheets with you, and it's about a series of about 13 sheets. But it literally takes you through that estate planning process. When you name yourself, your heirs, maybe charities, and then it goes further on to sort of put together what you have out there as far as your assets. We don't necessarily need all of the account information, but it's really, those worksheets come back to you at the very end of the process, and they're designed to, for your executor, so that they can see what you have out there. So in going back to that, the healthcare document, you think about who your agent, who you want it to be, and then Ross will have that discussion with you about, any questions you have, what their abilities are, what they can and can't do.
Yeah, and it's not only making medical decisions, but making maybe housing decisions. If somebody needs to transition into a higher level of care, and we have, as our Spotlight partner and as our educational partners, a lot of places that provide, transition housing. When somebody can't live safely on their own. I've got a client who is, so there may be some underlying mental health issues, but she also has a dementia diagnosis. And she is bound and determined that she will never leave her own home. That happens to be a very common theme. She's at the stage with her diagnosis that she's very angry about everything and very suspicious and resistant to common sense things. Like the doctor says you should take this pill. I don't want to. That doctor doesn't know what he's doing. And is quickly becoming unable to live safely on her own. And the healthcare power of attorney allows somebody to, if she can draft one, would allow somebody to make a decision to help get her into a place where she can be safe and independent. Or maybe there's in-home care. Maybe there's in-home health care or non-medical health care that can come in and help keep someone in their home for a long time. A lot of, I think there's a big, maybe misconception, especially among a certain generation, that it's either you live at home or you go to the county home. And the county home is where families put their people who they don't love. And today there is so much more in continuum of care and all of that. So the healthcare power of attorney lets somebody that you trust help make those decisions. Another thing that it can do is nominate a designee for final dispositions. And so Iowa, my context for recent, as I get older, is this has to be 15 years old. But a recent change to the Iowa law is that you can designate somebody who will be responsible for final funeral and burial and ceremony arrangements. And that can either be a separate document or it can be included in your healthcare directive. And Shannon, with Caldwell Parish, and I talk about that a lot because when she sees families come in, if someone has not done any pre-planning, then the family collectively has to make a decision about burial or cremation, or what kind of ceremony to have, and how to maybe dispose of or divide up cremated remains. You don't want that. You don't want body parts floating around. But it is an incredibly useful and really overlooked little piece, because without that designee, it is either, but the law says it's a majority of the heirs. As a practical matter, any funeral home is going to want all the heirs to consent to whatever it is that you decided to do. I just got a call. What?
The brother and sister that we just had.
Yeah.
There was a family that came in and the brother wasn't able to make it into town. Oh, sorry. The brother wasn't able to make it into town before they decided on how to work with their remains. And they ended up cremating before the brother got there. And so he was a little upset about that, not necessarily that she was cremated, that he wasn't there.
Yeah.
Made that decision.
Yeah, he did ask a couple times, like, can they just do that? You know,
Right.
why didn't they have to check with me? And luckily, it was not a thing where he was adverse to his sisters. I've got another one right now, going through probate litigation, because right as we're ready to close the estate, one brother is complaining that there's been no burial or no interment of his mother and father's remains. And that his brother just took them and won't tell him anything, and wants the judge to put a stop to the closing of the probate because this issue about final disposition has never been addressed. And of course, the final disposition happens way before the family ever comes to me, right? I mean, it happens at the beginning of this process, not when you go call the attorney. But, and I'm not sure that the probate court is the right arena to resolve this matter, but it's causing a lot of time and expense and heartache for this family because they are fighting about who's going to do the ceremony, where the urns are, and where they're going to be buried. Having done a 144C designation would have been dispositive and put somebody in charge of making that decision.
If I can interject, when we met before for some introductory conversations, a couple of scenarios you mentioned that I wanted you to still bring up was that Illinois, where they did an online document, as well as the second was insurance policies. As far as the documents.
Yeah. Okay. So this is good. Okay. So I've got another local client of mine whose parents now just mother lives in Illinois, and the family mailed my client a copy of the parents' recently done or the mother's recently done estate plan documents, right? And it is they pulled it offline and filled it out themselves. And they put down it has to be witnessed, in Illinois, it has to be witnessed by 2 independent people. So both of the kids acted as the witnesses on this power of attorney. And someone said, oh, and that's right, because in general, an interested party can't also witness this. It has to be a neutral third party. The other thing they did, because they didn't have any assistance or they didn't check with an attorney, they had a financial power of attorney. We'll talk about that in a second. And it said that it's effective upon death, which also is not right. The financial power of attorney exists while you're alive, and the trust or will takes over after you're deceased. So making the financial power of attorney effective only upon death is basically they just wasted paper, and they did it incredibly wrong. So that is going to be an issue in the future, and of course I'm not licensed in Illinois, so I can't help fix it. But that is just, trying to do things on your own is often not the best result. And sorry, what was the other one?
Insurance policy.
Oh, yeah. Okay, so again, going back to Shannon being up there with us, I had this, and we just had this, was it yesterday?
Yes.
Okay, the weeks go fast. So, it was yesterday. So we have clients who are talking about how to, in the context of this healthcare directive and final disposition act, the best way to ensure that their kids have money to pay for the funeral arrangements, right? And she went through 3 scenarios that are like not good. So she's like, oh, so first of all, can we just give a little more money in the will to one kid and give them instructions that $15,000 or $20,000 is supposed to be used for the funeral? And like, yeah, you could do that, but that is my very least favorite way of doing that because they don't have an obligation to use that money for what you wanted them to use it for. Your kids are probably fine. They probably will do that. But there's always the worst case scenario where somebody says, hey, that's not a good idea, or somebody gets sued, or somebody gets a divorce, and all of a sudden that money that was supposed to be earmarked for a funeral is now gone for something else. Then she said, well, hey, well, we just have well, my kids have access to the bank account right away. And the answer may, there might be a slight delay because the financial power of attorney terminates at death. So the ability of somebody as a financial POA, that ends when the person dies. And so the banks often sort of freeze the account of a deceased individual until there are some additional legal documents that are presented. So there might be a bit of a delay in accessing that money, even though there's a robust checking or savings account there with the money. Then she said, well, can you just buy a life insurance policy? And the answer is, well, kind of. I'm sure you can. I'm at the point where I'm getting the AARP, give you $15,000 with no medical check. I get those like every day in the mail. And so, yes, you can do that. Yeah, that is a viable way of then paying for final arrangements, but it takes time to process that insurance claim. You have to submit a death certificate, which you don't get until after you've already had the funeral ceremony. And then you have to wait for that company to process the claim and pay you out. Most funeral, and this is not negative, but most funeral places, because they're businesses, they don't extend credit. So you either, pay them or take the casket out the door and go find somebody else. Probably the best way of doing it is to prepay and purchase an irrevocable life insurance policy that all the funeral homes around here use. I think it's homesteaders. That is a policy that you can buy ahead of time. It's transferable to any funeral home that you need and choose, and they'll transfer your body from wherever you are, and then all kinds of things. So that is instantly available for funeral burial arrangements. That is what I would do. That's a little far afield with the actual power of attorney issue, but it's good advice. So the other thing, just real quick add on the second part of that healthcare proxy is the living will. So the healthcare directive, or the healthcare power of attorney nominates somebody to make a medical decision for you and to assist you while you're alive with doctors and services and housing. The living will expresses what you want done in an end-of-life situation with regard to the administration or withdrawal of life-sustaining measures. So you can lay out that you want to be kept alive on machines forever. If you're the senator from Kentucky, if you can put in there that you want just a straight DNR. If somebody is in a declining state, they may very well want no life-sustaining measures used. We just had that come up too. She said to the doctors, please don't do anything. Because they came and said, she's, our age. But they said, hey, you're going to be paralyzed on your left side. And she said, I don't want to live like this. One daughter said, Mom, you're wrong. We can get you services, we can get you help, we love you, we want you to live. The other daughter says, hey, we should honor Mom's wishes. And luckily, not luckily, and the opposite of luckily, whatever that is. She had 2 more massive strokes and died. So the kids did not really have to make that sort of ongoing decision, but our client had not yet done her own estate planning, and so had not really mapped out and written down for the benefit of her children what it is she wanted. She was thankfully able to articulate.
Right, and that makes it so hard because we do what's called an outbound signing, where we would go to the family either in the home, in the nursing home, or at the hospital, and have the client provide us with that information and sign a power of attorney over. If you do not want to, put yourself or your children in those kinds of circumstances where you're basically making true end-of-life decisions only days before, it's just not, I want to say fair, but that kind of worry for yourself and for your family members is just a challenge, and it's hard. And it's hard for us too, because as much as we worked with this family for quite some time, and we were really looking forward to settling the estate, as were they, because it had been sort of a tumultuous journey for them and us, but mostly for them and their family. And it was just coming to an end, and I just really think that, how stressful it was, and then she got sick, and then had a stroke, and again, she was about our age, and just kind of hearing of that just really broke my heart, because, she really wanted to get things done, but she was in the middle of this probate matter, and unfortunately, she passed before she could even enjoy any inheritance, any, settlement or anything like that. So just kind of keep that in mind. It's the powers of attorney and things like that. I mean, they're necessary and they're a hard discussion for some people. I have a hard time talking with my own mother about end of life, but it's necessary, especially as you get older. And then again, some people don't get that chance to get older because things happen. So when you think about your estate planning, it's not always just for you, but think about your children and who carries on after you're gone.
Yeah, that's a good point. Do you believe it's a good time to?
That everybody ought to have, and it's useful again while you are alive, is a durable financial power of attorney. And that is a document where you nominate somebody else who is going to help manage your finances, your assets, pay your bills, sell stuff if you need to, make applications for insurance, enter into contracts at long-term care facilities. So these things kind of work together. You've got the healthcare, power of attorney where somebody is sort of arranging for services. The financial power of attorney agent is the one who's helping pay for it. They can be the same person. They can be different, depending on the skill set of your family and trusted friends. It's really simple to do. It's really important to do. And then it either works really great or it becomes an issue. And we have, again, I have a client who has dementia diagnosis. I see a lot of those. And having an early Alzheimer's or dementia or Lewy body diagnosis does not preclude doing estate planning. The bar for competency for executing estate planning documents is relatively low. But I take care to really work with people to make sure that they are understanding what they're signing and it's the right thing, it's what they want. And somewhere in there's a line for, grandma ought not to be signing this now because she has no idea what's going on. But we do work with a lot of clients who have some sort of cognitive impairment. But I have a client who has substantial assets, and she has accused her daughter of stealing her money. And a review of her finances indicates that the daughter is not in fact stealing. That is a byproduct of the diagnosis. But what this client is doing is paying third parties way too much money to provide basic services. Paid her dog walker $4,500 because the dog walker asked for it, and she also helped her do a couple other things. Took her to the grocery store, bought groceries on my client's dime for both the client and the dog walker, and then wanted to also be paid an hourly rate for transporting her to the grocery store. So, a financial power of attorney agent could step in there and take care of those finances and make sure that the legitimate bills are being paid and that services are being provided. In-home medical, non-medical care is a wonderful thing. And absolutely, they charge an hourly rate, but there's a contract and there's an expectation and there's a training. There's a vetting of those employees, and they have insurance, and they have, things, like licensure to make sure that they're the right person. Asking your elderly neighbor to come over and sit with you for 5 hours a day, instead of going to independent living, or instead of hiring a professional, and then having that neighbor ask to be paid later on, creates all kinds of problems. And it creates a financial drain, and it also creates an issue with the potential heirs who now have questions about where the money is and where it went over time.
Another question on those powers of attorney that we get is, what do you do when your name is on the account, and do you change the name on the account? Do we add people to that account? So.
Yeah, okay, so there's kind of a couple things embedded in there, because it's a very natural response from a lot of people to go, hey, I'll just add my kid or kids onto my bank account as joint owners, and now they'll have access to the money and they can help me pay my bills. I don't like that. I don't like adding people as joint owners, because it makes your money their money in the eyes of the law. Bankruptcy, lawsuits, divorces, all that kind of stuff, all of a sudden your money is getting flagged as belonging to that person. It is much more prudent to just add them as signatories, able to sign checks or conduct electronic banking business, but it's very specifically not an owner of that money. One of the provisions that I go over with my clients in the durable financial power of attorney is the section that says, because this question comes up so much, the agent does not take on any liability. So mom's bills don't become your bills just because you are her agent under a financial power of attorney. And that I think is it seems so very natural to me, because I've been doing it for 3 decades, but most people, that's a really valid question. Hey, if I start signing my name on this stuff, do I become liable for these debts? And the answer is no. You're just stepping into the shoes of the original owner. So yeah, so the financial power of attorney, very good to do. Some of that hard. Yeah.
Is that true if it's a trust also?
Okay. That's a great question. Is that true if it's a trust also? Is it true that the trustee takes on any personal liability for your debts? The answer is no. The question is, can you use a power of attorney to circumvent a trust? The answer is also no, and I'll touch on that in a second. That's you actually asked a really good question that has about 16 different parts to it. So here's the downside of a financial power of attorney. Again, it's a wonderful thing. You ought to do it, put it in place, do it now while you're competent, nominate somebody you trust. Iowa law is pretty permissive in the way that a power of attorney can be revoked. And oftentimes, going back to the first client that I was telling you about, who has some cognitive impairment and is in that really angry and paranoid stage, she says she doesn't want her daughter to be her power of attorney. She'll tell anybody who listens, no, she steals from me. She can't, she's not supposed to be in charge of my money. And so when a provider, when a banker, when a service entity looks at that power of attorney, says daughter, the person standing in front of you says, no, she's terrible and she's stealing money from me. That person is very likely to go, we don't want to touch this because we don't want any liability. So a power of attorney can be revoked pretty easily. The solution to that is to go into court and establish a guardianship and conservatorship, which is, it takes a lot more time, a lot more effort, a lot more money to go and prove that somebody is not competent in order to get an order that says somebody else is in charge of their stuff. The other downside of a power of attorney, and this is why we are so very careful in working with clients, is it's really easy to be abused. You can pull it offline and fill it out yourself. And we have seen multiple instances of somebody who, suddenly there's assigned power of attorney after this person has had a moderate to severe diagnosis for Alzheimer's, giving just one person, and it's often like somebody who's really random, like one grandkid, or the daughter who lives in California and never comes around, is suddenly the power of attorney and is doing all kinds of stuff. We had one case where the girl, she was operating on behalf of her dad under a power of attorney. She swore up and down that he wanted her to buy a house, so she took $350,000 of his money and bought herself a house in Georgia. And you can't do that, and you can't do that. I mean, one, you can't benefit yourself by being the power of attorney, and two, you can't steal money. What if he needed it? I mean, it's stealing, but what if he needed that for his ongoing care? The other two siblings were a little miffed that she had taken $350,000 for her own use. Yeah. And that became a whole legal litigation nightmare. So,
Is that true in all states?
is that true in all states? Probably. Because usually there's some version of the Uniform Power of Attorney Act that has been enacted, and they almost all say something like, yes, you can revoke it, and yes, the agent can't self-deal. It's called self-dealing when you use mom's money for yourself and not for her. So yes, almost all of the states have something there.
Is there a review of how the power of attorney is?
So is there a review of how the power of attorney spends the money?
Ooh, what a great question. Go, Liz. No, because literally, this just came up. We don't have to dig too far back into history to come up with really good stories. We have to go like back 4 days.
My understanding is that there is not a specific review, but they ought to be transparent.
Yeah, that's an interesting answer. So, I think the agent who is handling someone else's money has a legal and a fiduciary and a moral obligation to keep track of all the stuff. Keep a spreadsheet, be able to, in an instant, show what you spent money on. Is there a requirement that you get together periodically with everybody else and share that information? The answer to that is no. So there isn't any sort of statutory required oversight disclosure thing. And like Liz said, I think best practice is to be as transparent or to be ready to be transparent. But we have had a family that, the doctors call it the daughter from California. The estranged child who hasn't really had any contact with the family and suddenly, in a crisis situation, comes into town and wants to be in control of everything. I know best. I know that mom and dad had $1.2 million 10 years ago, so they must have $1.2 million now. Where did it all go? Somebody took it. I know what's best for mom's care. All that kind of stuff. So we have this situation where our client is actually the older individual. And, she's 90 something and is a delight to talk to, but has a tad bit of age-related forgetfulness, which is not dementia. And when she tells a story, it kind of rambles. But she's confident. She knows what she wants. And she's told me on multiple occasions exactly what she wants. And she knows where her money is. And she knows where her money is, and she knows who she wants to be in charge of it. And it's not the daughter from California. And so she's in there demanding an accounting from the power of attorney. And wants to litigate over this. We have to get into no, you're okay. We're spending money the way it ought to be done. It's okay. So sometimes family dynamics, make me change my answer as to what you strictly have to do. But yeah, the good practice is always be very precise, very transparent, keep track. Yep.
Does the state of Iowa require that the person that you assign as power of attorney reside in Iowa?
Ooh, good question. Okay, so does the state of Iowa require that the power of attorney agent be an Iowa resident? And the answer is no. You can have somebody outside the state of Iowa be your agent and trusted contact. And that there is, so this is actually a really good transition to a will. So,
Is that the case in most states?
is that the case in other states? I don't know. I would guess yes, but I'm not 100% because I'm only licensed. Financial power of attorney nominating somebody, and it can either be effective right now or it can be effective whenever you need it. And then the last thing is some sort of testamentary instrument. So a will, a last will and testament, is just a written document, has to comply with Iowa law. But it allows you to nominate somebody who's your executor, who wraps up everything, and it allows you to direct where all your assets go. Iowa law technically says that your executor needs to be somebody inside the state of Iowa. And specifically what the code says is that you can have an out-of-state executor if they also have an in-state co-executor partner. But the code goes on to say, comma, except for good cause shown, which is legal weasel words that get you out of the first thing that was the requirement. So my belief and my understanding from working a little bit in the legislature is that is a holdover from a time when it was difficult to travel. You know, it was we didn't have email and online banking and FedEx and overnight flights. You know, I mean, so it was difficult for somebody to wrap up matters remotely. Well, now all that has changed. You know, we have had several. I've lost count of the number of the states where we have never actually met the executor face to face because they live out of state. I shouldn't say that. We met them probably once when they were in town or something, but almost all of our interaction is, remote. We've got video conferencing where we can easily meet with somebody. We work all over the state and, help people in.
He's actually a gentleman whose spouse passed in a tragic accident, and he's homebound. And he made the call to our office in regards to assisting with some probate matters. And I've never met him, but I've spoken to him on multiple occasions. And it's actually, it's quite nice to be able to have access to emails and, Zoom calls and things like that. But we're moving along quite nicely in not having really any interruptions, aside from the World Cup and mail going, 12 days instead of 5. But other than that,
for some reason, the World Cup really interrupted mail delivery all around the state of Iowa.
In town, people were saying, I haven't received things yet. And I think it was like 7 days later she got it.
Yeah. But, so yes, can you have one executor who lives outside the state of Iowa? Absolutely, yes. The other stuff that the will does, and this is also important, and we have way too many stories to tell on this one, but I said at the beginning, the will needs to comply with Iowa law. Okay, and it's pretty easy. It's got to be signed by the testator, by the person doing the will. It has to be notarized. It has to be witnessed by 2 disinterested witnesses. So it can't be heirs, it can't be spouses. It has to be 2 disinterested witnesses. When you go to use the will and prove and submit to the court and get it ratified as being valid, you have to provide testimony affidavits from those 2 witnesses. And those 2 witnesses have to say, yep, we were there, we knew each other, we knew the person who did the will, that person asked us to be witnesses, we all knew each other, we signed it, and yep, that's my signature. Now, that can be a bit problematic to track down witnesses even, a few years later, much less decades later. So Iowa law allows you to do that affidavit right at the time the will is being done. It's called a self-proving affidavit, and it just gets tacked on to the back of the will, and it contains all that stuff, so you don't have to go locate dead or moved away witnesses in the future. We keep seeing wills that are wrong, that are not notarized. They're not witnessed correctly. There's no self-proving affidavit on the witnesses. We sort of inherited the estate planning files of an attorney who passed away recently. And not one of those is anyway. I've got to go find, we had to send somebody out to Altoona to go knock on a woman's door and say, "Is this your signature from 1987?" She's like, "Yeah, that is me." And it's so that's a bit frustrating. It adds a bit of extra time to that. So go look at your wills and make sure that they're signed and witnessed by two people who are your immediate family, beneficiaries under the will, and everything's notarized, everything's buttoned up.
Can I interject with a question there? So if you do find that, is there a very high percentage or is it a low percentage that voids that?
That's a good question. So, if a will is defective like that, it can be rehabilitated if we can track down the witnesses. Often, what we've found, and we've been sort of lucky in the sense that if we've had a defective will like that, the distribution under the will would be the same as if there wasn't a will. So Iowa law has a whole has a will written for you in the intestate statute, where it says, hey, if you have a spouse and all your kids are also that spouse's kids, everything goes to your spouse. And if you have kids, it all goes to your kids equally if you don't have a spouse. It does say that if you're on like a second marriage and you have kids that are not that surviving spouse's children, half goes to the surviving spouse and half goes to the kids from your prior relationship. And that's been a bit of a surprise to some of my clients who expected that their surviving spouse would get everything, and instead we've got to track down stepkids who might be estranged from that new relationship and to try to give them money. So that's something to look at. So doing the will is a good thing, even though the statute kind of helps cover some of that if the will is effective.
So I don't know when you're going to interject this, but one of the things that we really wanted to get out of this is questions to ask. I know in our talk beforehand, the difference between wills and trusts, because it's very complex, you said, to know. What are some of those initial questions if someone has no idea where to start? What are those first questions that they should ask?
Before we move on quickly, I just want to make sure that when you are thinking about your will and thinking about items to leave, make sure that you either let family know or you document really well about who you want things to go to. We have had more time and unfortunately expense on people not receiving what they thought was theirs or they thought was theirs.
Well, you had a great turn of the phrase. I'm sorry that they want to hear something was. Would you say you're not like theirs or
They thought was theirs, theirs.
Yeah.
And so you just want to be sure to have that documentation out there because we have thought, this is expensive litigation over things that were really not there. A baseball card, a ruby ring, a picture, grandma's Afghan. And it is expensive and timely and exhausting because you're working with a client and trying to work through her feelings. And boy, it's
yeah, and it's always it's personal property, right? Stuff that doesn't have a title. It's not the house. It's not the bank account. It's the ceramic frog, and the cast iron skillet, and the Ken Griffey Jr. rookie card that is supposedly worth $35,000 and nobody can find it. Or gold bars. If you take nothing away from this meeting except this, do not own gold bars. For God's sakes, because they don't have titles. And some people think there's more than what actually turns out there. And it's, one of our clients, $700,000 in gold for her dad. Like, okay, is he a pilot? Or is it's a good investment, it's gonna go up, but oh my God, it's so ripe for, fighting about that. Those two brothers who are fighting about their parents' cremated remains are also fighting about mom's jewelry. That may or may not be worth anything. And no offense, but there are some jewelry pieces that are beautiful and expensive, and then there are some jewelry pieces that you wear every day and they are worth scrap value. And everybody thinks it's the first one. Everybody thinks that this is an heirloom piece that you can take into Antiques Roadshow. You're going to get $2 for it. But it's really not. It's sellable by the pound to some place. So, my God, if you have specific things that you want to go to people, put it in a list. There's a reference in a will or a trust to an attached memorandum that then has to be honored, and then those specific things get distributed to specific people, and there's no litigation over surrounding frauds. Now, Lisa really wants me to get the difference between a will and a trust, and we'll kind of end on that, and then open up to questions. So a will, right, easy to do, nominate somebody as your executor, indicates where you want your assets to go, you do it, you put it in the drawer, somebody passes away, you pull it out, and you may have to go through the process of probate. We talked about that. So probate is the court-supervised administration of a decedent's estate. Having a will does not get you out of probate. That is a common misconception. We've had lots of clients who said, hey, I tried to take this will to the bank, and it says right there that I'm the executor, and they said I needed court documents. And I'm like, well, they are right. Because what the process is you have to ratify the will, the judge signs an order, court issues documents that appoint and vest the executor with power. And that is the authority to go act and do things like get at a frozen bank account or sell real estate. Almost always, it is the selling real estate issue, because you have a home that all the owners are deceased and now nobody owns it. And you have to go to court to get somebody vested with the authority to be able to legally sell the real estate, to be able to meet with the realtors and sign the listing agreement and sell the house. The good side of probate is it provides in case the whole family's gonna fight. There's a referee in the probate judge, and we can go and litigate and hash out all of the issues. It's also pretty straightforward. In that Iowa is different than some other jurisdictions. California is terrible, Arizona is terrible. But Iowa's pretty straightforward in terms of the documents that have to be filed and how you get through it. The downside of probate is that it takes at least 6 months and probably closer to a year or more to get through everything. And there are required notice periods that build in time that you have to provide a 4-month window for creditors to file claims, for example. So those kinds of built-in time sinks make the process lengthy. Selling the house can take time. Marshaling assets can take time. Paying off bills and getting things sometimes takes time. So then it delays the closure for the family a little bit. But again, it's also just, it's a time commitment for somebody. The other downside of probate is that it costs money. The executor and the attorney are each entitled to a fee that is roughly 2% of the gross value of all of your assets, including beneficiary designated assets that aren't necessarily going through probate. So oftentimes, the reason you have to go through probate is because you have something that didn't have, a beneficiary designation by previously, or a fee. But all of the other stuff, all of the investments that you've done through 50, that gets swept back into the calculation for attorney's fees. I happen to think that's pretty unfair, and I don't treat my clients that way. And Liz can back me up on that.
I agree with that very much.
But that is what the statute says. So, somebody with a $400,000 house and $2.6 million in investments in a Charles Schwab account that went right to the kids as soon as you died, fees are getting calculated on $3 million. The way to avoid that is to stay out of probate, and that's where a trust comes in. So a revocable trust, a living trust, an inter vivos trust are all words for the same thing. It is an entity that you establish during your lifetime. You set it up, you run it, it is your money, you have full access to your money, and it creates an entity. It's kind of like creating your own business, except that it does not have a separate tax ID number, and you do not pay taxes at the trust level while you are alive. So it is a disregarded income tax entity. But the trust owns your house. The trust owns your bank account and your money market account and your investments. And so when someone passes away, you don't have that failure of ownership that requires court involvement. Instead, we just swap out who the trustee is. And the successor trustee, as outlined in the document, has the authority to then go sell real estate. A trust is more expensive to set up on the front end, but saves a significant amount of money on the back end by staying out of the probate system. And it settles as quickly as you can talk to Lisa and sell the house. So I will leave you with that little teaser, because I think I am out of time.
So if you had to wrap up maybe in 5 to 10 words, what you conveyed today, what is it that they should do for next steps?
Liz already wrote it down. Go, Liz.
It is never too late to do your estate planning. One last story is we had a couple come in and she was 86 and he was 93, is that right?
I think so.
And they sat down in front of us and said, "We're here to do our wills for the first time." And I said, "Congratulations, welcome to our office." It was awesome.
You want to wait for the kids.
Yes.
But yeah, so, do something. Not doing anything is still a plan. It's a terrible plan. Being a tad bit proactive makes it so much easier for you, so much easier for your family. It can be fun isn't the right word, but not intimidating. I mean, it's on a regular basis. Liz described that intake process in the beginning, right? You call us, she sends you a worksheet, you fill out the worksheet, you come in and you talk to us. People routinely say, making that phone call was the hardest part of this whole thing. Deciding to make the phone call was the most difficult part of this. Why did I wait so long? So, it's never too late. Do your estate plan. Thanks, Mike.
Very good.
Thank you.
So, but my kids know very well that I don't want to become alive if I can't function. So, how does that work when you're at that point and then they have to keep you alive or not, or?
That's a really great question. That is a very, so the question is about if you are an organ donor. And let's say you have also basically said, hey, I don't want life-sustaining measures. How do those two things fit together? The healthcare directive that I use has an organ donation section, whether or not you're an organ donor, if there's any limitations on stuff. But it also has this section that says, hey, if the medical professionals determine that the death process needs to be suspended temporarily to be able to assess the viability of organ donation, that's okay, and that doesn't violate my please do not resuscitate anything. So there's a little legal language that allows to start that process. Yeah.
And the second question is, I have twins, so they're very competitive. And so I have the one in Iowa is the executor, but he is married and his wife is very sharp.
Okay.
And do I need to do anything about letting her, I mean, it's kind of, I don't want the other son to say, oh, well, the wife is going to make all the decisions, but yet she is going to need to have a lot of input.
Okay, so that is a really great example. She has twins. One twin lives here in Iowa and has a wife who's very smart. The other twin lives out of state. The in-state twin is the primary agent and executor, but the concern is hey, is his wife doing all this and making all these decisions? And, I don't know maybe what the answer to that question is, except that, I would, if somebody presented me with that question, we need to talk. We need to sit down and really talk about family dynamic and how to ensure that somebody doesn't feel completely left out of the process and resentful, but you're still nominating somebody who's getting things done as efficiently as possible. And it's different for every person. Every family is unique in its own way.
And you just have to be very clear with your wishes. Once you designate someone, just be very clear with your boys or girls or that you are, expecting that they all work together, and make sure that if you want somebody to designate, that you write that down, that you do have it as agents. But it's your choice because it's your estate planning and the way you want things done and the way you see things clearly. There's obviously a reason why you want her involved in some way. And so I would be vocal about that. Don't be shy about what you want for yourself.
It's my understanding that one of the reasons to get a drug is because we're home. But for example, can you hear me?
No. One of the reasons for getting a trust is because you are something?
Can you hear me?
Oh, no. Yes, okay.
It's my understanding that if you're a home, then that's one big reason to have a trust.
Yes.
But somebody like me who owns a home, I recognize that something could happen and before I die, I may not have a home. Can you tell me what the advantage would be to a trust?
Okay, so there's another really good question about family dynamic, changing circumstances, because this is estate planning is not just a thing, right? It's much more of a continuum. Young couple with a newborn kid needs a will to nominate a guardian for that kid in case something happens. People who are in the middle of their prime earning years need different planning than people who are retired and transitioning. And the question is, hey, owning real estate is one big reason for having a trust, because it keeps you out of the way. What if you then don't own a house at some point in the future? Do you still need a trust, or is it advisable? And again, my answer to that varies a lot. If you came to me and said, I don't own real estate, I live at Dave's place. Sorry, Dave. If you live at Dave's place and you come to me and you say, I have investments and I have beneficiary destination, I don't own any real estate, ought I to have a trust? I want to trust because all of my friends have a trust. Or when I go looking down the assessor's page for the homeowners association of the place I used to live, they all have trust after them. Can I please have a trust? I would say I would be stealing your money to get to a trust because you don't have any probable assets. You don't need it. We met with an older couple that came here from Arizona. Yeah, don't move to Iowa from Arizona. But they had a trust done a decade ago, and they do not own real estate here in Iowa. And it's like, yeah, you have a trust, I'm not going to undo it, but you don't really need it. So we're just going to touch up their powers of attorney a little bit and just leave their trust the way it is and not change it and not rehabilitate it into an Iowa compliant trust. So, it's to answer your question, it's very dependent upon you and where you're going and my analysis of the best, most cost-effective way to get you to your goal.
I have a question about a power of attorney.
I am a backup power of attorney, my mother does not want to be. You know, and they say that, how's the best way to handle that? Do we need an affidavit from her that she doesn't want?
Okay, that is a really good question. She has a power of attorney. She is the successor, the backup agent. Your mother is the first, and she doesn't want to do it because
She's 86 years old.
she's 86 years old and she doesn't want to do it, right? So that makes sense. Yeah, a really simple, like, declination, and if I were doing it, I'd probably notarize it just to say, hey, I decline to be the first power of attorney, and then it triggers the succession
I just attach
attorney.
that to
Yeah,
the power
yeah,
of attorney.
and that shows, you know, because if you're presenting it to me or the banker or whatever, to Vicky, you know, you've got, or, you know, you're trying to sell a house, and the realtor wants to know who has authority. Now it's documented, and we see why the first person in line isn't the person who's signing pieces of this.
Okay, we've also run into issues where somebody's saying they need a doctor's,
Yeah, no, they don't. Okay.
and the doctor's office is saying, no, we don't do that.
Yeah, okay, that's a really good question. Okay, so hang on. So the power of attorney can be effective either immediately when you sign it, or upon a future event, which is generally that person becoming incapacitated. Okay? And the way I write my powers of attorney, it's either a doctor's note or two doctor's notes confirming that this person does not have capacity and ought not to be making their own decisions, thus triggering the power of attorney. So you get a bank that says, you know, we want to see the doctor's notes. Well, one, that's a HIPAA violation, right? They don't need your personal, private, family's medical information. There is a method in the Iowa code for somebody like an attorney to sign an affidavit that says, I've reviewed the medical records of my client, and you can trust me that this power of attorney is now in effect. And there's some indemnification of reliance language in that affidavit so that the bank is covered. They don't need the doctor's reports. But that comes up a lot, where, you know, random mortgage companies want to see a doctor. No, you don't. No. So, you know, there's still a certain amount of, like, privacy involved. You gotta get back to this guy here. He's been waiting. Hold on.
Show his sheet right here.
1 second.
If a person has various assets, IRA, stock, savings accounts, that have a pay on death, can they be excluded from wills and trusts?
Ooh, okay, good question. If you have assets that have either beneficiary designations or POD, TOD, payable on death, transfer on death designations, banks and credit unions can do that with their checking and savings accounts. All investments and life insurance want you to put a beneficiary on them. Those things, so the beneficiary designations control prior to a will or a trust. So that designation, that contract that you have with that company comes before the will and the trust. So if you have, you know, life insurance designated to just one kid, but your intent in your will is to make a 50-50 split, they're gonna get the life insurance outright. So.
Okay, two-part question. I've done my will and all the documents. And I'm single, I have no children. I only have 2 immediate family members living out of state, who probably won't be that present when stuff is going on. So we have named 2 different banks as executors, and then my niece and my brother as number 3 and 4. Number 1, is having banks as executors a good idea?
Yes.
Well, okay, so this is does everybody hear that? So this is a really common circumstance. A single or widowed individual, not a lot of immediate family. Maybe you have no kids, maybe you're not around, maybe you're estranged. You don't really have anybody to be in charge of all of this stuff. That happens so much, and there is right now no real good solution. there was supposed to be a legislative commission created in the Office of Alternative Decision Maker that would provide a pool of people who could go be a power of attorney for somebody who doesn't have anybody else. But it didn't really get any funding. So it exists on paper only, it's not really a thing. So the question is, do you turn to a third party? Do you turn to a bank or a trust department? The answer is for executorship, for trusteeship in wrapping up affairs, absolutely. Most of them require some sort of minimum dollars under investment in order to want to do the trust. The best example was Wells Fargo 2 years ago, dropped all of their trust management except for individuals with $10 million or more. So for most of us in here, Wells is not a viable trust department. There are others that have much lower entry, around $300,000, which is a much more manageable figure. But does the trust officer at Iowa State Bank want to go to your house and check on you and see if you're paying your monthly bills and if you need extra groceries? The answer to that's no, right? I mean, yes, a bank can manage the money, but there needs to be sort of an intermediary, somebody who can be either the power of attorney agent or a trust protector or some other kind of person who is a liaison between the individual and the corporate entity. And so there's no good answer to your question because it's a problem.
And then the second part of the question is, okay, so I have all these executors on my will. Is the bank required to work with the family? Like, I have this spreadsheet that's almost done, that I have, I have family stuff, historical stuff that I want to go to family. Are they required to give that to, the family or?
Yes. Okay. So if you've made a list of items of personal property, or even just other instructions for how to wrap up your affairs, does the bank have an obligation to do that? Yes. Do they desperately want objective direction like that? Also, yes. I mean, the last thing, right? It's like I get asked on a regular basis to be the executor, and I'm just the attorney, but I don't just, I don't want to go guess which of your nieces gets the ring, right? I mean, I want written instructions. I don't want any subjectivity to creep into the analysis. So, yeah, so you are better organized than most people. Good job. Okay, last one.
Which document was it that you said my bills do not become their bills?
Oh, which document did I say your bills don't become your agent's bills? The financial power of attorney. So stepping in order to, manage assets, pay bills, make sure stuff gets done, does not make the agent personally liable for any debt.
One question about organ donors. Is there a time frame that the family can be sure is the right word, that it's going to take 2 weeks, or it could take 3 months, or is there any ruling that says this must be done so that the family can proceed with the funeral and all that?
For a time frame for what?
Organ donation.
Is there a time? I don't know the answer to that question. Shannon knows the answer to that question. Is there a time frame for organ donation?
Great question. Okay, so for organ donation, if someone is an organ donor, it will say on your driver's license. Let's say if you pass away at the hospital, they will know if you're an organ donor. What happens is they reach out to the Iowa Donor Network at that time. They contact your next of kin, whoever's going to be in charge of your arrangements. They ask a lot of questions, what they are, I don't know. If you still qualify for organ donation, they receive you into their care at that time, so it's a pretty quick turnaround. And then we would receive you right after that. So all that takes place quickly. And again, it's just going to be whoever's in charge of your final disposition.
But it is weeks, right? It's
It's
24
not,
hours.
it would be immediate, because usually they would get your money, within a few hours. So donation can only take place within a certain period of time. You're welcome.
Thank you all for coming out today. I'm sorry